Welcome to the Ask the Experts show with local experts in the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
Hey, good evening. I'm saying good evening. I must have gotten 5 emails last week, people going, when you say good afternoon, we think your show is taped when you're coming on at 6 o'clock. So we are live. Through how we've ever done this, I do not know, but this is the first Thursday of the month, so that means Kaye Rembaum, and I knew the phones were going to ring off the wall, which they have been. We've got Robert Kaye, the senior partner at Kaye Rembaum, and I just want you to know, Robert, the phones are ringing off the wall. I knew it, so I came up here to the studio. Welcome to the show.
Thank you, Steve. And hello, everybody.
Can you hear me okay?
I hear you. You hear me?
Yeah, barely, but I can hear you. So your phones must be ringing off the wall.
Well, we're having a lot of calls, a lot of emails. There's a lot of questions as to what people should be doing, can be doing, and how to be addressing the concerns of the residents. And it's a very difficult time for many, many people.
So now, are your offices closed right now?
Our offices are closed to the public. There is some staff that are working, but most of the attorneys and staff are working remotely, so we're available to our clients.
Okay, so your wife hadn't kicked you out yet, right?
No.
So tell everybody, because for some reason I just feel we have a lot of new listeners. Listenership is up since this has started. I hate for it to be for that reason, but tell everybody about Kaye Rembaum.
Well, Kaye Rembaum is a full-service law firm in South Florida that handles primarily representation of community associations, condominiums, homeowner associations, cooperatives. We do it at 3 offices, our main office in Pompano Beach, an office in Palm Beach Gardens, and an office in Tampa. We've been providing the services to community associations continuously since 1992 and provide the services for the complete aspects of operations that community associations face, be it addressing issues of covenant enforcement, covenant interpretation, collection of unpaid assessments, advising in situations such as we're facing now as to what the board can and should be doing relative to protecting the residents.
Well, all the questions, we get all these questions during the month that you're not on, and almost every single question is about the coronavirus. And like I said, our phones are ringing off the wall. If you'd like to call here, if you have a question, condo association, homeowners association, if you're a board member or a management company, you can call us here at 888-565-1470. It's 888-565-1470. Let's go right to the phones. Sherry, are you there? Shelley, I'm sorry.
Yes.
You have a question for Robert?
I'm sorry?
Do you have a question for Robert?
Yes, I do. I live in a small HOA. We've got 34 homes, 7 members on the board. The board president recently brought in chickens, which is a deed restriction violation. He said that the reason being was regarding, he was trying to give solace to one of his children, and we all live on 2-acre lots. We allow horses and cows if they're not for commercial breeding, and ponies or house pets, but no chickens. So it's caused quite an uproar. There have been several letters written, and we did have a couple of meetings 2 years ago that did not have a quorum at it. They did have a vote, and the vote of the few people who were there turned out to be more of a poll. So my question is somewhat twofold. There's been a certified letter that was sent out by the treasurer. There was no meeting, but she sent out a certified letter saying that they had 30 days to remove the chickens. So is that in violation? We didn't have a meeting because of the COVID. The second one is the question that I have is the board liable to be sued by the homeowners because there have been chickens in the past? So would we be open to liability? Number one, the board was not aware of it when they brought in the chickens, and they put it in very plain sight. But we didn't. Anyway, those are my points to be addressed, please.
Okay, Shelley, and you said that the president said that the chickens were for what purpose?
There was some stress. His daughter had stress and anxiety attack, and so he felt that would because of the issues with COVID, and they've been taken out of school, and they have been just very stressed that it would help.
How long have the chickens been there?
Since 2 weeks.
2 weeks, okay. Well, it's difficult to address enforcement of a covenant violation in these times, primarily because the court system is not functioning in its normal capacity, and that's ultimately the way that enforcement goes in this. The fact that it's the board president makes it a bigger problem of addressing by the board, and that the board does need to reach consensus on pursuing violations, and while it's not allowed to take action by email, it is able to reach a decision, and as long as it's ratified at a later time at a properly convened board meeting, that would be sufficient. So if the consensus among the remaining board members, other than the president, is that this is a violation that should be addressed, then that's not an issue for the treasurer to have notified the president of the need to cause a removal. Now, the president is trying, it seems, to set it up so that the chickens can be considered an emotional support animal, correct, and that would exempt them from the limitations of your covenants, and you need to give the reasonable accommodation. But in order to qualify, the president would have to present the association with documentation from a qualified medical professional that identifies that the occupant of the home, the child, has a disability that interferes with major life functions, and that these particular chickens are necessary to alleviate that and allow her full use and enjoyment of the premises as anybody else would have under fair housing laws. So they could come back with something like that, but at the present time, they haven't given you anything. They've just made vague reference to, she's stressed out, so we got her chickens. So that's what you're facing at this point. The board doesn't have personal liability for enforcing its documents or failing to enforce its documents. The association as a corporation could have exposure to liability, and there could be a claim of breach of fiduciary duty by the board for failing to enforce if there is such a provision that the owners want enforced and they're not. So those are the basic issues that you're looking at.
Right. Well, how would they prove a breach of fiduciary liability?
Well, they would prove it only by demonstrating that there's a covenant that identifies a violation and that the board knowingly allowed the violation to continue to the detriment of the community. Because once a violation is allowed to continue as to one of the properties, then it applies to all of the properties, and the board would no longer be able to prohibit that particular issue. So proving it's not that difficult. Proving damages is a little more difficult. But they could achieve a court order that compels them to pursue it. If
The
that's
homeowners could get a court order.
I'm sorry?
The homeowners could get a court order, or the board?
Well, if you're talking about the homeowners against the board, that's one option. The homeowners can bring the action directly against the other homeowner. Chapter 720 of Florida statute does contain provisions for homeowners associations that allow any individual to bring a legal action against another member for a violation of documents in the case that the association does not.
Mm-hmm. Okay.
Thank you, Shelley.
Thank you.
Good luck with that.
Mm-hmm.
Let's get one more call in before we go to break. Hello, Joan.
Hi. I have a quick question. Is it true that a condo owner who votes against a particular amendment, and that amendment gets passed, does not have to abide by the new amendment since he voted against it?
As a general rule, the answer to that is no. But there is an exception to that, and that is if the association is adopting rental restrictions involving either the ability to rent or limitation on how many times you can rent in a year or moratorium, anything that affects an owner's free ability to rent, in that instance, if the owner doesn't vote in favor of it, then it's not enforceable against that owner until they sell the unit.
Well, what
But
the
all
issue
other
is...
amendments,
Yeah,
all
yeah,
other
not
amendments
the-
would be applicable whether they voted for it or not, assuming it got the sufficient number of approvals from the rest of the owners.
The issue was they wanted to limit the ownership to only buying two units per owner because they were trying to stop the hotel effect. Well, the owner bought four, and he said, I didn't vote against it, so I don't have to follow. The amendment went through and said only two. So he was right. He was correct then in buying two more because he didn't vote. He didn't vote for it.
He's wrong. It's enforceable as to him. It's not limiting his ability to rent his units. It's limiting his ability to buy more units, and that's not covered by this statutory change. So if there's a validly approved amendment that limits the number of units anyone can own, then he's limited to that number even if you voted against it.
Oh, because, all right, I see. So he had no right. So the amendment went through, so anybody that voted against it, they cannot buy more than two units, correct?
It applies to every unit owner in your condominium.
Thank you very much. Love it. Thank
You're
you.
welcome.
Thanks, Joan. Hey, let's
Thanks
go to
for
break.
listening.
Give everybody the phone number at the office.
1-800-974-0680.
Okay, we're going to go to break, and we come back. We've got more people on hold. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And we are back. This is, without a doubt, our most popular show of all the Ask the Expert show. It's Kaye Bender Rembaum. They do community association law, one of the top law firms in Florida, not just here in South Florida. And guess what we're talking about a lot today? If you'd like to call in, and we've got a board full of calls, phone number here is 888-565-1470. I'm going to go to Joni because she's been holding a long time. Then we're going to talk about also what's coming up for Kaye Bender Rembaum. Hello, Joni. Joanne.
Joni, are you there?
Joanne.
It's Joanne.
Hi, Joanne.
Hi. So my question is related to a condo association. I'm a president.
I can't hear
for...
the-
Can you speak up?
Yeah. Hold on. Okay. Can you hear me
That's better.
Okay. I am a president for a condo association, and we have a condo where we've had a person living there for about 3 months. Beyond the 29 days they were allowed to visit, and they haven't completed an application to either be an occupant, to be an occupant. And so we've sent them a letter and telling them that they need to move out. But what is the next step as far as removing them, evicting them, or what's the right legal process?
Well, a lot of that is going to depend on what your documents provide for relative to violation of this type. Sometimes the documents will contain a provision that allows the association to go in and basically be the agent of the owner and evict the person. Other times, when they don't provide that, then you're going to be bringing legal action against the owner and the occupant to compel the owner to cause the occupant to remove, basically get an action or an order from the court that tells them this is what they have to do. At the present, if they're not replying to your demand, this is one other option that if you're inclined to allow them to stay, if they fill out the documentation necessary and go through the approval process, arbitration is available to compel that. So either you want them gone and then you go to the courts, or if you want to compel them to submit the appropriate documentation for the consideration of association approval, then that's an arbitration action through the Division of Condominiums Arbitration Section.
Well, they've been asked twice to complete the paperwork to have the occupant application and background screening completed, and they have not. So we're at the point that we think eviction is the right course of action.
The association attorney should be brought in and make a written formal demand to do whatever it is you want them to do, either the application or vacate the debt. Sometimes when they get mail from the association, they don't take it as seriously as if they get something of a more formal nature from an attorney. So that is often helpful in moving the thing along. It doesn't always work, and you end up having to deal with it through the court process, but that is an option that you should be doing first.
Okay, very good. Thank you.
Thank you for holding.
All right, thanks for calling.
So, what are you guys going to be doing now with your classes?
Well, unfortunately, for the present time, all of our classes are canceled.
Okay. Nothing online?
Nothing online yet. We're working on looking to establish something on request. There is some opportunity to do an individual group setting, but at the present time, unfortunately, we had several classes scheduled for April that have been canceled already. May is likely going to fall into the same category. Hopefully by June we can be back running. But we do board member certifications for both condominium and homeowner associations as well as cooperatives throughout the year. We have some other classes that we give as well, dealing with updating governing documents or addressing potential liability issues or fair housing issues. Many different topics throughout the course of the year. We do them in our office, and then we also have our Ask the Attorneys. Unfortunately, our last one for the year in April, which was scheduled in Boca, had to be canceled as well at the Sugar Sands Park, so that one will not be happening this month. But listeners can go to our website at kbrlegal.com and click on events and see what's coming up.
Okay. Wow, it's strange not doing, the certification classes and the Ask the Attorney. This is really strange. Hey, we've got
a board. These are very difficult times we're dealing with right now.
Let's go back to our phones. Let's go to Maria.
Hello.
Hi, Maria.
Hi. I have a question. I'm a member of board for a homeowner, for a HOA. So before all the meetings were canceled, so the property management company contract was about to expire. So in the last meeting, we approved that we were going to continue with the same company and renew the contract with just modifying the cancellation terms of the contract. And that was documented in the minutes that we were going to continue with the same property management company with just modifying the cancellation terms. And that was accepted by the property manager and the board. So recently, when we received the contract for signing, there were new sections and a new schedule of charges that was not there in the contract that we had for prior years. So my question is, can this contract be signed without a meeting to approve the rest of the terms, the new terms and the new schedule of charges that include some new fees for the homeowners and some new fees for the association to pay for services that were included in the flat fee before? So, and also,
are these changes are the changes being proposed things that the board considers acceptable, or are you against them?
Against them.
Right. Well, at your meeting, you approved the contract as existed. There was no proposal that you were considering with new terms, and you negotiated a change in just the termination provisions, which is all that you've agreed to. By the property manager presenting this to you with different terms, new terms that weren't agreed to before, in essence, the manager in legal terms has rejected your proposal for contract and offered something else. So at this point, the board has the option of accepting it or rejecting it, and of course, trying to negotiate on those items as well. That's basically where you stand. You're not bound by these new terms, and if the manager wants to back off and go with what you've agreed to, then you would be bound by that. But even by virtue of the fact that he's submitted this new contract, the law views that as a rejection of the earlier one, which doesn't give the option to go back to it. It's a your option if you want to go back to it. Or you
Yes,
can
but
accept
my
or
question is,
negotiate
I'm
what he's
saying-
giving you.
What I'm saying is, we have no time right now because we are not meeting currently. So, let's say we have to sign it just because we have no other option. Do we need a meeting for those new terms, for the new schedule of charges?
Well, you can do meetings by telephone or by video conferencing. There is a app that's been exploded all over the place, Zoom, which I've seen a lot of people using, which allows for a number of people to be participating in the meeting at the same time, or you can set it up with a call-in number. Everybody that's interested in participating in the meeting calls in, and it's like a conference call of sorts, so nobody is physically together for it. The other option for the board, if you agree with accepting the contract and want to approve it and not have a meeting, so if the board is unanimous, then you can just sign a written resolution to that effect without having a meeting. All the board members would have to sign it. They don't have to do it all at the same time. And they can do it electronically in different parts, and that would constitute the board approval. But if you do sign it, then you're going to be bound by it.
Thank you. And what's the procedure to announce a teleconference meeting for the rest of the community?
You broke up at the beginning. Repeat your question?
What's the procedure to announce a meeting to the rest of the community?
Okay.
Like, if it's a teleconference meeting, how do you announce it?
How do you normally announce it?
As a sign by the entrance of the community.
You could do it the same way.
Okay. Thank you.
Thank you, Maria.
So much.
Okay,
Thank you so
good luck.
Bye-bye.
Let's go to Bonita.
Hi.
Hi, Bonita.
Hello. I have a question.
Hello, Bonita.
Can you hear me?
Yes, we hear you fine.
Yes, go ahead.
Fine. I read recently that Congress is currently debating a bill which would completely stop collections for 120 days after the state of emergency is lifted. Will this stop? I can understand stopping collections if someone was in collections, like in legal collections, or sending someone for collections because they're over the 90 days. But is this going to also be stopping the assessments being collected for 120 days after the emergency state of emergency is lifted?
What you're referring to is a suspension of mortgage foreclosures, of federally backed mortgages only, for the time periods that you're indicating. It has nothing to do with maintenance assessments that are owed to the association. There's no legislation currently that has any effect on whether or not an association can pursue collections of assessments through the lien and foreclosure process. And so associations are able to do so. The potential difficulty at the moment is that the court system is not fully functioning, and some communities are taking a wait-and-see approach during the time of most of this quarantining. Some of it's more compassion-oriented, some of it is business-related, but the association assessments are still an ongoing obligation. There is no suspension, there is no forbearance, unless the board chooses to do that, which is a very drastic measure and not one that's recommended, because the association still has to pay its bills and meet its obligations, and without the assessments from the unit owners, there's no way to do that.
Okay, thank you very much.
Oh, you're welcome.
Okay. Hey, Robert, give everybody your phone number again if they'd like to contact your office.
You can contact Kaye Rembaum at 800-974-0680. You can write to us at info@kbrlegal.com. You go to the website at kbrlegal.com, and there's a prompt there. You can click on to be contacted by a representative of the firm.
And if you have a question for Robert, you can call us here at 888-565-1470. We're going to go to break. When we come back, we'll have Manny.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680. You are listening to the Ask the Expert Show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 5 to 6 p.m. Now, get ready for more Ask the Experts.
We are back. We are on every Monday and Thursday from 6 to 7. And the show is called Ask the Experts. The first Thursday of the month, we always have Kaye Bender Rembaum on with us. And Robert is always willing to answer your questions when it comes to community association. We have Manny on the phone. Manny, do you have a question for Robert?
Let me just interrupt you for a second, Manny, if I could. While we were on break, I got an email that indicated that the governor has announced he's going to be signing an order that will be affecting foreclosures and evictions for a 45-day period. And the order's not written yet, but that's likely to come later this evening. I don't know at this point whether it affects association assessments or not, or just lender foreclosures and tenant evictions, but we'll have more on that as it passes. So go ahead, Manny.
Okay.
Hey, guys, thank you again for doing this. Robert, you're very much respected and loved for doing this. Thank you. So my question is, we've got an annual meeting coming up in a couple weeks for an association. It's a 3-member board. It's a condo, and they only have 2 meetings a year, unless it's a strict emergency. They have their 2 required meetings a year, budget and annual. And annual, coincidentally, was scheduled for the middle of the month. Usually it's not heavily attended, but 10 to 20 people attend. And as of right now, they don't have any form of teleconferencing as of right now set up. So assuming that they don't go that route, is there anything that we members can do or say to make sure or advise that this gets postponed and moved to a time to either they do get set up with teleconferencing so that, for obvious safety reasons, can they still have this meeting, this annual, at this time during this crisis, putting people's safety on the line if 10 or more show up?
Well, at the present time, the law doesn't say you can't do it. It says you need to exercise social distancing. I'm assuming it's within the premises. You're not going out to another place to have that. So within the confines of the private condominium, there's no prohibition on having the meeting. A great many communities are postponing their annual election meetings that happen in March and scheduled for April, and they very much to do that. The Division of Condominium came out last Friday and indicated their opinion that the emergency powers that are set forth in Chapter 718 for condominiums, 719 for cooperatives, and even 720 for homeowner associations, for which they have no jurisdiction, in their opinion, they say that all applies, and within those emergency powers is the power to cancel meetings and hold them at a different time. So they certainly should be considering doing that if it isn't a situation that's conducive to the right atmosphere of social distancing. While in the election process, nobody really needs to physically be there for it to happen other than whoever's counting the ballots. If they want to do it by a telephone system, you can hook up to a number, call in for a conference call for however many people it is. It's not that complex of a arrangement. But if the board is not considering, and the members want them to, I suppose the best method of addressing it is don't go, and you don't have a quorum, so nothing can happen. If not 20% vote in the election, they can't have an election either, but the downside is the board can just roll over for another year. So if that's not the goal, you may have to end up going through with it.
Okay. I appreciate the heads up, Robert. Thank you for your time.
Thanks, Manny.
Thanks for listening.
Hey, we have a line open now. If you'd like to call us here, it's 888-565-1470. We also get so many emails in during the 4 weeks that Robert's not on with us. So we're going to read some of these, and we'll let Robert answer them. This is a board member from Pompano asking, as a result of the coronavirus, unemployment is way up, assessment delinquencies are edging up. What is our association supposed to do?
I'm sorry. I didn't catch all of that. Can you one more time?
This is a board member, Mark from Pompano. As a result,
got that one. Okay. I got that one, Steve.
Okay.
That's similar to what we were just talking to a prior caller about with respect to assessments. I think that clearly associations should not be just stopping all assessments, waiving or a moratorium on assessments, because, as I said, these assessments are what operates the community, and the community must continue to function for the benefit of all of its members. And without the regular payment of assessments, it can't do that. So while it could consider on a case-by-case basis with owners who may be affected and having issues, working out some kind of a payment plan, or considering waiving any late fees or possibly interest, those are some potential possibilities. But I do anticipate we're going to see situations not that different to what we saw in 2007, 2008, 2009, when there were a large number of delinquencies within the communities, and the associations needed to be much more involved in pursuing and aggressive in pursuing, in order not to let them get too deeply into a hole. Because the other side of the coin is that if you put off your assessments and say, well, you don't have to pay for 3 months, and then in 3 months, give me 3 months worth, that's not necessarily going to help anybody.
Right, yes.
Because 3 months down the line, they now owe 3 times what they otherwise would have, and it becomes much more difficult for the individual to meet that obligation. It's going to be different than it was in those prior years, because the lender closures are likely not going to be facing the same wave that we had before, at least probably not until 2021, based on the recent changes in the law to allow for forbearance for up to a year and a limitation on the ability of federally backed mortgages to pursue foreclosures. So the associations aren't necessarily going to be facing that same problem, at least not this year, but the board does have to be diligent in making sure that it doesn't ignore the need for its funds.
Seems like some of the board members are kind of at each other's throats lately. Here's Rob from Boca Raton. He said, I'm a board member. What do you think about, I want to resign from the board because I don't agree how the board members are handling things during the virus. Should we be meeting each month?
Well, I often tell members that are thinking of resigning is that you can do more good or you can accomplish more for the community if you stay on the board, if you're already on it, than if you resign. Because once you resign, then you basically are just another one of the owners who the board can or doesn't have to listen to. And if you're on the board and you can build a consensus with enough other board members to be a majority, then the issues that you're trying to accomplish, you might be able to have a better chance. As we mentioned earlier, you can continue meeting and doing it in a remote fashion as opposed to physically being in a room. Many of our clients have adopted such procedures. If you have business to conduct, you should be having meetings. I mean, the community still is an ongoing entity that has issues that are coming up beyond the coronavirus situation. Although that's an important issue, that's not the only issue.
Okay. Let's go to Arlene. Hi, Arlene. Do you have a question for Robert?
I do. Hi, Robert. Glad to hear you're back.
Hello, Arlene.
I'm secretary on the board of our association, and we've had people that have asked us whether we were going to waive any maintenance fees during this time. So our feeling was that instead of waiving it, could we delay them paying, in other words, allow them to pay it up to 30 days late and waive the late fees? And then,
well, that's along the lines of what we were just talking about. Okay. We're not recommending that be on a blanket basis for everybody, because there are people who are continuing to pay and can afford to pay their regular assessments. But if you make a blanket policy of just delaying everybody, then you're not going to have the necessary funds to operate. So it's preferable if you can to address it on a case-by-case basis, have the owners approach you on the board to ask for kind of consideration, and what you're proposing of 30-day grace to pay it without penalty is certainly reasonable and is something within the authority of the board to do. We just think it's better for your association if you do it on a case-by-case as opposed to across the board.
Okay, and then just one other question.
Sure.
We have right now that people are allowed to come to the pool, but they have to be accompanied by an adult if they're under the age of 14. Should we have a higher age rather than 14? Are we leaving ourselves open for possible lawsuits when they're minors and they're by themselves at the pool?
Well, I assume you're not housing for older persons in your community by what you're asking. There is certainly a concern of a potential exposure to a discrimination claim based on familial status and affecting families with children under the age of 18 when you limit access. But when there's a health, safety, welfare issue that's connected to it, the issue becomes what's the proper age and where, and it's difficult to focus upon. 14 is on the older side, but still an age where if they're not accompanied, there could be potential issues. That's going to be ultimately a decision of the board as to what seems best for its community as a whole, with the understanding there is a potential that somebody could make a claim of discrimination. Where are you located? Which county?
We're in Broward.
You're in Broward. Okay. Broward is a little more, I don't want to say lenient, but less aggressive in pursuing that type of a limitation than, say, Palm Beach County, but it's still something to keep in the back of your mind.
Okay, because
but the pool is certainly an area that is worth having that type of restriction.
Okay, so maybe I'm not understanding. It's okay for them to come by themselves, or are we leaving ourselves?
No, it's okay to have a limitation on children coming to the pool without some form of adult supervision.
Okay.
The issue becomes what's the right age, and you say you have it at 14. I think 14 is a reasonable age. Higher age would become less reasonable because as children mature, they're likely to have a safety issue, and then it becomes more of, are you just targeting them because they're annoying to other residents and the way that they behave at the pool, which is not something that you can limit in that fashion under the discrimination laws. So, that's the concern.
All right. Well, we were also concerned because the pool, we were looking to let people come in later. Obviously, right now we're not doing that because of the health, going on. But the pool is now going to be open from dusk to dawn, and we were thinking of opening it up until 11 o'clock at night because we have new lights on there. So our concern was, any minor coming on and there's no one to observe them.
Okay, thanks, Arlene.
It's certainly a reasonable restriction as you've described it.
Okay. All right.
Thank you
very much.
Hey, Robert, a lot of the emails that we got, it seems like a lot of the properties are, because of the virus, we're actually closing their pools up now.
A lot of them are. In fact, in some of the counties, it's mandatory. Broward County has not reached that level yet, but I believe earlier in the week, Palm Beach County issued an order that requires the closing of all private pools in communities, not individual homeowners, but community pools, which would pretty much cover all condominiums.
Right. Wow. Okay, let's see if we can get one more call in. Let's go to Rich.
Yeah, good evening.
Hey, Rich.
Good evening.
We have a annual meeting election that was postponed, or it's going to be postponed indefinitely till after the virus is abated, or we don't know whenever that is. But we didn't feel it was safe to have an annual meeting with elections where there'd be a lot of people around required to conduct an election. The question is, we had 6 candidates for 5 positions for the board. Now, when the virus is abated and it's safe to have the election, do we start from scratch again and do another 60-day notice, or can we just do a 14-day notice for the 6 candidates that had put their name in the hat earlier?
When you announce the postponing of the annual election, you would only go from the second notice forward. So the individuals who put their name in timely for the original meeting would be the only candidates. Now, the board certainly has the option to start over again if they want. It's not the preferred method under the circumstances, but they really can go either way on it. My recommendation is they start with the second notice with the same candidates.
Right. And then as far as declaring it safe to have it, that's not indefinite.
Well, we're hoping it might be sometime in May, but it may not be till June.
Yeah. Okay, very good. Well, thank you very much for clarifying that.
Thanks, Rich.
Thanks for listening.
Wow, a lot of I knew there was going to be a lot of calls today. I knew that.
Yeah. Well, we're always happy to have a lot of calls.
Yeah, a lot of board members, too. Tell everybody, I like to end the show this way, tell everybody why they should hire your firm for their association.
Well, we have a great many years of experience in focusing our attention on community association law. We have a significant number of our attorneys are board certified, meaning we are specialists in the field as declared by the Florida Bar, which is a very special category for attorneys to be in. And besides the knowledge and experience, we also what we like to consider more consumer friendly. We're available as needed. We are accessible. Our policies are to provide prompt, efficient, and understandable information to our clients in a cost-effective manner. And that's our mission statement. That's how we've managed to grow to where we are today.
Customer service is so important to your firm.
Absolutely.
Give everybody the phone number, and you've got such a great website with so much great information on there.
Well, the phone number is 800-914-0680. It is kbrlegal.com. Visit it, check out the resources page, check out the COVID-19 resources tab that we've added recently with a lot of good information there. We have Rembaum's Association Roundup. We have Legal More that have articles of topical interest to board members and issues that they're facing on a day-to-day basis. And for those who use our services for collection, we also have 24/7 access for the status of every matter that they've got going that is confidential to their community.
Well, I love doing this show with you. We always have so many callers. You've got so much great information. And so do you think you'll be in studio next month?
Well, we're going to take it day by day, but certainly hoping so.
I hope you are too. Listen, stay safe. Thank you so much. The name of the firm is Kaye Bender Rembaum Association Attorneys, and they're with us the first Thursday of every month from 6 to 7 on Thursdays. We'll be back with you on Monday for our wealth management show. Everybody stay safe.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O. The opinions expressed on the preceding sponsored